Hi, my name's Ned Cooper and I'm a PhD student in the School of Cybernetics at the Australian National University. I put this presentation together with Ellen Broad, an associate professor also in the School of Cybernetics. I want to start by acknowledging that I'm recording this video from beautiful Ngunnawal and Ngambri country here in Canberra, and pay respects to elders past and present. Ellen and I are interested in the regulation of algorithms used in high-stakes settings. For example, algorithms used in the domains of criminal justice, healthcare, education, and social services. And we're interested in the role of governments to regulate those algorithms, the models for regulatory bodies, the functions of those bodies. But for this presentation, most importantly, we're interested in the participation of the public in regulatory functions. Today, we want to explore how the public might participate in the functions of an AI safety commissioner in Australia. To do so, we're going to look at the Australian Law Reform Commission, which established processes to allow participation of the public in law reform almost 50 years ago now. We'll discuss some of the features and trade-offs of those processes. And while this presentation is focused on examples in Australia, we hope our presentation is useful to practitioners in other jurisdictions considering regulatory bodies similar to the AI Safety Commissioner. So what prompted our interest in an AI Safety Commissioner? Well, in 2021, the Australian Human Rights Commission released a report on human rights and technology, and it had a key focus on the development of use of AI in Australia. One of the major recommendations of the report was the creation of a new AI Safety Commissioner. And this was to help lead Australia's transition to an AI-powered world while promoting safety and protecting human rights. The four proposed functions in this commissioner were to work with regulators to build their technical capacity regarding the development and use of AI, to monitor and investigate developments and trends in the use of AI, especially where there might be human rights risk, to provide independent expertise relating to AI and human rights specifically for Australian policymakers, and then finally to issue guidance to the government and to the private sector on how to comply with laws and the ethical requirements in the use of AI. So alongside this and other recommendations, the report lists 5 principles of a human rights approach to new technologies. And the first principle listed is participation. According to the Human Rights Commission, this means ensuring participation in decision-making of stakeholders affected by new technologies. And this includes the public, affected groups and civil society, experts and decision makers. But while the participation principle is pretty clearly reflected in other recommendations in the report, particularly those recommendations that relate to government decision-making where it's informed by AI, it isn't clearly reflected in the functions of the AI Safety Commissioner. The report does encourage the AI Safety Commissioner to draw on diverse expertise and perspectives to fulfill its functions, but it doesn't outline how stakeholders would participate in the review of algorithms. We think that the AI Safety Commissioner should reflect the participation principle specifically through its second proposed function, and that is to monitor and investigate developments and trends in the use of AI. This will require engaging with perspectives from across society, including some new perspectives from new stakeholders created by the business models and activities of companies deploying AI. For example, this may include engaging with gig workers on the algorithms that govern their work, and also with online communities on content moderation algorithms. Today, we want to explore what processes will the AI Safety Commissioner require to conduct this monitoring and investigatory function guided by the participation principle. So looking at the Australian Law Reform Commission, and I'll refer to it as the ALRC from now on, the ALRC engages the participation principle to support its role to make proposals for law reform in Australia. And we suggest that reviewing those processes may provide some guidance to the AI Safety Commissioner on the processes necessary to allow the participation of the public in monitoring and investigating developments in AI. According to Justice Michael Kirby, who was the first Australian Law Reform Commissioner nearly 50 years ago, law reform is the technique of conceptualising a legal problem, bringing in social data and seeing a legal problem in its social context. And a good law reform topic, according to Justice Michael Kirby, is one where extensive consultation may elicit new perspectives and ideas and enable individuals with diverse views to contribute to the law reform process. So the ALRC is an independent agency, though the law reform topics it investigates are commissioned by the Attorney General of Australia, who's a member of the government of the day. After receiving a commission, the ALRC then consults extensively to understand the social context of laws before it finalises its proposals to the government for changes to legislation or policy. So both Ellen and I have participated in major inquiries by the ALRC, Ellen in inquiries relating to copyright law and intellectual property, and myself on inquiries relating to the over-incarceration of Aboriginal and Torres Strait Islander Australians. And so what does that consultation process look like? Well, for every project, the ALRC assembles a team of advisors from a variety of legal and non-legal perspectives. And that advisory team works with the ALRC to develop the reform proposals that are ultimately delivered to the government. But the ALRC also conducts more public consultations. And so in addition to the advisory committee, public consultation can be engaged through discussion papers, open forums and webinars, and websites with information about the process underway. Through these mechanisms, law reform bodies have to present the existing laws and their effects and describe alternatives and envisage their effects in a manner and a language that enables the participation of non-legal parties. So by way of example, the consultation process for the most recent inquiry that I was a part of, that involved 22 advisory committee members from across government, the university sector, and the Aboriginal and Torres Strait Islander community. It had 141 stakeholders participate in a national consultation process. So those are the forums and the webinars I discussed earlier. And then finally, 127 submissions came from individuals, but also organisations in response to a discussion paper, which was produced after the national consultation process. So these engagement activities, they're all geared toward ensuring public participation in creating proposals for reform to government. But we must also recognise the resourcing required of participants in these processes. Many smaller organisations may not have full or even part-time staff to respond to ALRC inquiries or other inquiries from other commissions. And as such, resources can be redirected from service delivery to respond to such inquiries. Without resources, such organisations just don't participate in the process. Next, we want to discuss how are ALRC recommendations implemented? Well, the ALRC has no direct role in implementing its recommendations. There's also no statutory requirement on the Australian government to formally respond to ALRC reports. Nonetheless, the implementation of ALRC reports has remained relatively high. As shown on the slide, by 2018, the ALRC had completed 89 reports, and 86% of those reports had either been substantially implemented or partially implemented. So substantially implemented refers to the implementation of the majority of recommendations in the report, where partially implemented refers to implementation of at least one, but less than half of the recommendations in the report. And these levels have remained relatively consistent over the last 2 decades, even while the ALRC has completed 25 additional reports between 2000 and 2018. However, there are 2 other points we wanted to note in relation to the implementation of ALRC reports. Firstly, as previously mentioned, all inquiries are commissioned by the government of the day. As such, the inquiries conducted by the ALRC are not entirely independent of the intentions of the government of the day. And secondly, while the overall implementation rate has been consistently high, as at 2018, 25% of reports remained only partially implemented, and 14% remained not implemented at all. This indicates that a significant minority of reports, nearly 40%, remained without a substantial response by government. So the failure to respond to such reports after such extensive public consultation involving many resources for the organisations and people that participate, that can affect the trust and motivation of the public to participate in future processes. So by way of example, the most recent inquiry I was involved in led to what is called the Pathways to Justice report, and that's shown on the slide. The extensive public consultation led to broad support across interested parties and affected stakeholders for the proposals that ultimately ended up in the report to government. But today, nearly 5 years after the report was delivered, there's still been no formal response from the federal government. Implementation of the recommendations in the report has been minimal and almost entirely limited to state government actions. And this destroyed a lot of goodwill for those who participated in the process. Overall, the ALRC is well regarded for the processes it uses to engage the public in matters of law reform, but the model is not without its trade-offs. Here we summarise 3 trade-offs discussed in this presentation, as we think they're important to consider for the AI Safety Commissioner or any similar commissioner in other jurisdictions. Firstly, the processes require significant resources on the part of participants. Those resources may those requirements may redirect resources in small organisations away from service delivery, or they may prohibit participation by those organisations entirely. Secondly, the ALRC is not entirely independent of government direction. The Attorney General's role in commissioning the ALRC to undertake inquiries limits the ALRC from investigating areas of the law that might be really challenging for the Australian government of the day. And then thirdly, while implementation of reports has remained high, for those reports that are partially implemented or not implemented at all, there may be public frustration where participation is not reflected in government action. Just one key difference I also wanted to note between the functions of the ALRC and the AI Safety Commissioner as envisaged by the Human Rights Commission, which conducted the report we referred to at the start of this presentation. The ALRC is focused on laws and policies solely within the purview of government. The AI Safety Commission, on the other hand, is proposed also to monitor and investigate algorithms used in high-stakes settings by government, but also in private organisations and civil society. And this leads to a few open questions. How will the Commissioner work with private organisations and civil society to undertake monitoring and investigatory work? How will the Commissioner ensure action on its efforts by those parties? And finally, will that require some sort of enforcement mechanism? To consider those questions, we encourage you to check out a recently released report by the ANU Tech Policy Design Centre entitled Tending the Tech Ecosystem, which is shown on this slide. Overall, we hope this presentation prompts you to consider how an AI Safety Commissioner might be set up in your jurisdiction to deliver the functions we mentioned earlier, guided by the participation principle. What are the trade-offs you might need to consider to enable those functions? If you have thoughts or feedback on this presentation, please contact myself or Ellen via email or on Twitter. Thank you.